Welcome back to Let's Brief It, a podcast made by law students, for law students, and produced by the DC Bar student community. I'm your host, Sade, a 2L at Howard University School of Law.
And I'm Amanda Hitchez, a third-year law student and president of the Student Bar Association at GW Law. In today's episode, we explore how judges take an oath to uphold the Constitution and are bound by precedent and judicial ethics. And yet, judges are also human beings who are shaped by upbringing, education, community, and sometimes faith. So today, we're asking, where do the First Amendment, professional responsibility, and personal faith meet, and where must they remain separate? We are honored to be joined by two extraordinary guests. First, Professor Tiffany Williams Brewer, Associate Professor of Law at Howard University School of Law. She teaches evidence, professional responsibility, and Black women and the law. She has served as an administrative law judge, a federal prosecutor, and a chief counsel. In addition to her legal scholarships, she is a pastor and founder of the Esther Project, working globally to advance women and girls.
We are also honored to welcome the Honorable Alexander Williams, a DC native and proud graduate of Howard University. Judge Williams earned his JD cum laude from Howard University School of Law. After serving as a state's attorney for Prince George's County, Maryland, he was nominated by President Bill Clinton for the United States District Court for the District of Maryland, where he served with distinction for nearly 2 decades. His career reflects a deep commitment to public service, leadership, and the law. He currently teaches public ethics at Howard University School of Law.
Professor Brewer, Judge Williams, thank you both for being here. Judge Williams, I'd love to start with you. Judges are expected to be impartial, but not necessarily value neutral. In your view, what is the difference?
Well, obviously, we all have to abide by the Constitution, our oath that we've taken as judges. But there comes a time sometimes when the ultimate decision or the judgment is contrary to our sense of fairness and ethics. And at that point, judges should be independent and understand they do have a role. And there is a constitution that's stare decisis, but I think there's an obligation of judges to sometimes speak out and question inconsistencies and question things that simply don't seem correct and right. So it is a difficult task sometimes. You've got to balance it, but the judges are the ultimate guardians of the Constitution and justice.
I'm able to ask a follow-up question. Do you find those two to be consistent most of the time, or usually inconsistent in terms of your values and then the opinions that you are publishing?
Well, again, I wouldn't say most on anything. There are occasions when there's an inconsistency between a ruling, a judgment, what the law is, and my own personal beliefs and background and morals and so forth. And when you get to that point, you got to be careful to not give the perception that you're biased or you're disregarding your obligations, but those things happen. As a judge, one of the most difficult situations I had were those federal sentencing guidelines, which handicapped me and caused me to have to give people much longer time than I would have given them had I been able to take into consideration some other factors. So those things happen, and I can't say it's that rare. Neither can I say it comes a lot. It's just from time to time, based on facts and circumstances, you have to look at it.
Judge Brewer, you served as both a judge and a scholar of professional responsibility. For law students, this tension can feel abstract. So what does discipline look like in practice, especially when the law leads to an outcome that may conflict with personal moral instincts?
Well, thank you for having me today for this important conversation. And I think the role of ethics in our profession and in the development of a future lawyer that a law student should be thinking about is really critical in this very hour. The first thing that I try to orient my students with understanding, both as a professor as well as from the perspective of having been a practitioner and a judge, is that there is an ethical responsibility that we have to our clients that may look distinct from morality, right? And what you may have thought ethics was for you as an individual person. So I think it's important to first explore, what is ethics to me personally? What informs my ethics, my morality, my sense of what is right and wrong? But as lawyers and judges, we have to go further. We have to look at even our role and our rules, the model rules of professional responsibility. It delineates out what the various roles are as lawyers. And that helps to remind us of what our duty and our obligation is, even in the context of our adversarial system, where we may be advocating and even for procedural protections, where, the classic question that students come into law school with is kind of, in the criminal defense sense. How can you defend someone you know is guilty, right? And so we're allowed to do that as lawyers and to represent people who we may not always agree with because we believe in the system. We believe in justice. And, something that is illuminating to law students, for example, is when you really think about it, right? Does justice mean that all people that are guilty are convicted? Well, under our system, all people who the prosecution is able to bring sufficient evidence that a jury believes beyond a shadow of a doubt, justice means they are guilty, right? And should be sentenced and held accountable. So, the first thing law students have to do in orienting themselves to kind of this shift of how do I go into the profession as an ethical and responsible attorney is really understanding the foundation of our legal system, the foundation of the Constitution and the separation of powers, and where they fit in their role as either an advocate, as a counselor, as an advisor. So it is a very special responsibility that we have as lawyers in the legal profession that I think is very unique to other professions, but it's an important one because we truly are guardians of justice in our respective roles.
There's often concern about faith influencing outcomes. Judge Williams, in your experience, does faith inform what you decide or how you carry yourself in that role?
Certainly, and thank you for the question. Again, all of us have some source or context of faith. Faith is a belief. It varies sometimes from time to time and person to person, depending on your background and experience. But there are some fundamental principles that guide all of us. And fairness is one, openness, the idea that both the rich and the poor should have an opportunity to be heard, and those sort of things. So faith certainly comes into play, but it does not permit the judges to disregard what the law is. One of the things that I've always found, first as a judge, then as a professor, and of course as an elected prosecutor, that there are disparities. Fundamentally, my beliefs and my morals that there are disparities, in particular, the system of justice. There's discrimination as to who you charge, who you investigate, who you arrest, who you seize, who you try and charge, who is convicted and sentenced and then ultimately let out. And all across the system, there are disparities. And I believe that fundamentally as part of my faith and my religion and so forth. But again, I have to balance my views on the system with my obligation as a judge to be neutral and fair and to have an independent judiciary. And where there's a need for me to intercede and intervene, I'll do it. But you have to balance that and not create any perception that you're allowing your faith to get in the way of the process of justice. So that's my view.
Thank you for that. I'm actually going to direct this question to you, Professor and Judge Brewer. So, in some cases, they touch on like really deep, resonated moral questions, whether it's reproductive rights, religious liberty, LGBTQ plus protections. I want to ask a question more so, how much does morality inform the law and ethics? And in your perspective, just through practice, where does that balance lie?
Well, I'm going to take your question in two parts, informing law and informing ethics. So I do think that society and societal beliefs do inform the law because there are elected representatives that are really doing the will of the people. So there are legislative enactments that can reflect the morals and values of the electorate, right? And the majority of the electorate that has voted, where there are referendum or voted for the representatives, right, that are passing the laws in the majority. On the ethics side, we have to go back to what role does morality play? Well, morality may inform our perception as we are at the table, those that are in positions of making recommendations, because lawyers, we're a self policed profession. So we come up with the rules that we want to have in place, whether it's in a state or even in the model rules of professional responsibility. So the individuals who are really proposing rules, sometimes, yes, they can be driven by their morality. Judge Williams talked about disparities, right? So sometimes your morality as a member of the legal profession can say, morally, I don't believe these disparities should persist. And so, therefore, I am motivated. I'm a member of the American Bar Association and chair of the litigation section. And I remember years ago when one of my mentors, Paulette Brown, the first woman of color to become the president of the American Bar, helped to lead the effort to revise the model rules of professional responsibility to include Model Rule 8.4G, which essentially makes it actionable for lawyers to discriminate on the basis of race, gender, and other protected classes. This was one of the most controversial of, ethics rules, and many states, even in an act of rebellion kind of and stance against it, even made legislative enactments to say that they would never enact that in their state and believe that it's unconstitutional, right? But a lot of the arguments that were made really in favor of 8.4G were rooted in morality as well. But lawyers felt that this is an area of our ethical obligation that is lacking. There's not accountability, and morally it's wrong given the impact of discrimination and the history of discrimination, not only in our profession, but in our country.
Professor Brewer, from an ethics standpoint, how should judges think about transparency? If the public could see the private disciplines that sustain a judge, like reflection, prayer, study, would that strengthen public trust or complicate it?
Well, unfortunately, I think religion is becoming politicized right now. So I think it may complicate it, unfortunately, right now. And I'm a deeply religious person and certainly never hide that in any way. However, like Judge Williams said, when we get on the bench, it's really about fulfilling we take an oath to fulfill our constitutional responsibility to uphold really the rule of law. So I think the transparency that judges have to really show is that they as individuals are putting their individuality to a degree aside when they put on their robe. Not, I shouldn't say aside, they're bringing their individuality, but it is subordinate to the responsibility that you have when you put on your robe to honor your oath. And it's important that we understand that judges are people. So the transparency I think that you're talking about is important. And that's why many judges are still involved in the community and so forth, and volunteer and are a part of the bar association and go and visit law schools. So you see the humanity of a judge. And I think that sort of transparency is important. And it's certainly what motivated me also when I stepped down from the bench to go into the academy and to really help raise up the next generation of lawyers in the profession. So I think that's a sort of transparency that's important.
Judge Williams, on that same line of reasoning, from a public ethics standpoint, as we've discussed, how does transparency, whether that is like reflecting prayer or disciplines that a judge takes in their personal lives, like how do you see that showing up as like a public ethics point of view? So more particularly like posting on Instagram, like following faith or, anything like that, being that as Judge Williams had highlighted that it is also politicized at this moment. So, how do you see, as a public ethics standpoint, a judge being transparent about their belief in faith?
Sure. Thank you so much for that question. And Again, there's a lot of tension between morality and our duties as a public servant. Once I took the bench, I didn't lose my First Amendment rights. And I've always, as Judge Brewer, as she said, we have to involve ourselves in community activities. And I went to a lot of conferences, I went to a lot of panels. I was guest speaker, and I continued to do that even as a judge. And I was then allowed an opportunity to talk and to express my views. And the only limit, again, is to make sure you didn't give any impression that you had some preconceived notions, and in any case that came before you, you would already have a decision as to what to do. So it's a balance, but you've got to do it. And I enjoyed it. And again, speaking back again as to the obligation of judges to make sure they implement fundamental justice and morals, I recall as a judge sitting, and if I saw anything that wasn't right or fundamentally unfair, I would speak out. And once in a while, I saw different guilty pleas being offered people based on race and gender. Sometimes I saw a position that prosecutors took with reference to sentencing recommendations or bond recommendations. And when I saw that, I would point that out. And that's because of the fundamental issues of fairness that I had and my morals and my beliefs. And I just couldn't stand mute when those things took place. So it's a balance, but you have to have courage to make sure that you are transparent and that you are the guardians of justice and fairness.
So, this question is directed to both of you. This podcast is for law students, many whom are trying to reconcile professional ambition with personal faith and identity. So, for students who feel called to public service but also are deeply rooted in faith, what does integrity in their careers look like very early on?
Well, I certainly am a person of deep faith, and I pray and have prayed throughout my career about every aspect of my employment and next steps and next moves, and that is a part of integrity for me. So I think one's faith tradition and one's calling, as you rightly say, right? Not resisting that, I think, is the fundamental root of integrity, right? Being honest with yourself about what your purpose is. For my first year law students, I require them to do a vision board and to think about who are the clients that you see yourself representing. What are the problems that you see yourself solving with your law degree? And to think very deeply about, what is their personal significance that they are meant to make to the legal profession. The positions and the roles, they will play themselves out because there are many different places and spaces that you can work and develop skills that help you fulfill your purpose. But ultimately, I think you really have to have a sense of direction, personal significance, and purpose early in your career to guide your authenticity and your integrity.
And I would add, certainly agree with that wholeheartedly, that I tell a lot of law students, I speak with them a lot, that you've got to make sure that you preserve your integrity. That's the key reputation for professionalism, preparation, hard work, and integrity of justice. What's important to me, and I'm so glad you all are talking about public service for law graduates. That's so important that you assume these jobs as the public. But for me, the most important responsibility of being a public servant is to preserve, I call it the rule of law. And under the rule of law, again, you want to make sure that the public understands that there's fairness, there's openness, there's transparency. They have to get involved. I tell students how they can help me. I need judicial independence. That'd be part of that. That's the role of judges. And law students and young lawyers have to make sure that they take the steps necessary to assure that judges are not shot at, threatened, trying to be impeached, and all of those kind of things. And I think that the law students should understand their role in the rule of law and in upholding the integrity of our system. So that's how I see it.
This conversation reminds us that the judiciary isn't simply about rules and citations. It's about restraint, it's about accountability, and it's about the discipline to ensure that justice is administered fairly. even when no one sees the internal work required to do it. Judge Brewer, Judge Williams, thank you for modeling thoughtful public service.
It is our pleasure.
Thank you so much for having us.
This is a rich conversation, and I think it reminds us that this is about humility as well. So thank you personally, Judge Brewer and Judge Williams, for sharing your wisdom and your experience with us. And thank you all for listening to Let's Brief It. If you enjoyed today's episode, don't forget to share. Until next time, I'm Sade Ajayi.
And I'm Amanda Hitchez. Thank you.
The DC Bar law student community strives to engage and support law students before you graduate and expose you to the tangible benefits of joining the DC Bar and DC Bar communities. Curated programming allows law students to participate in leadership trainings, substantive content programming, networking with practicing attorneys in fields of interest, writing opportunities, and other activities designed to expand your legal education beyond the classroom. Make an investment in your legal career by joining the law student community. To learn more, visit us at www.dcbar.org or email communities@dcbar.org.